All right, everybody. I'm still, I'm still working on my new format here. I'm uh, I'm undecided if I like it or not. So far, not sure. I'm not ready to. I'm not ready to say that I like it. Maybe though. Maybe after tonight, right? Could be. Could be. Whew, it's nice to be back to my regular time here, which is 7 o'clock Central. So it is pretty nice to be starting to get a routine again, everyone. Things just went a little crazy for everybody, I'm sure. So we've been trying to figure out how to get ourselves put back together again, right? Right. So it's been a lot. But welcome in, everybody. Welcome. Hopefully, my goodness gracious, it's only Tuesday. I thought we were on Thursday, at least. That would have been nice. Hello, Willie B. Hello. My goodness, that would have really been nice. But no, it's Tuesday. Sorry about that. I've made myself sad now. It's only Tuesday. Ooh. Yes, great. Well, and I'm going to try to keep it now. I think I'm in a good place where I can kind of keep it more in the evenings when I want to do the big documents. So during the day and in the morning, I might have just, a couple little things, but in the evening is when I like to do the full reading. So, hello, Appalachian Kentucky man. That's a great name. Oh, we love it. So tonight, everyone, how am I doing tonight? I'm doing okay. I don't think I would run into a burning building right now, but then I think if I was 100%, I wouldn't do that either. I'd be like, oh, that's tragic. And then I would shove other people towards the door. The biggest thing that would happen if I was running for a fire is I would be in the way. That's the big thing. Oh, Big Papa. Hey, welcome in. Hello, June Marie. Oh, goodness gracious. Yes, thanks, Kaya. A friendly reminder to kind of share this out. My schedule's been kind of bonkers, so I'm hoping we'll be able to get back on the road again. Hopefully, we hope these things will happen. Hi, Mama Vanna. Hello. I don't run. Well, right. I mean, I don't know. I think if I don't know. Are you supposed to run if there's a bear coming? I'm not sure. I feel like I get the wrong information. They're like, climb up a tree if a bear's coming for you. Then everyone's like, no, don't do that. And other people are like, curl up in a little ball. We'll just play with you. And other people are like, no, don't do that. So, and then some people say, get in your car and drive away. And people are like, no, it'll chase you and your family will be unalived. So I chuckle because of how ridiculous that situation is. If we could get the experts to come in and explain to us what we're supposed to do, that'd be great. I'd appreciate that. Hello, Lee. Hello, welcome. Hello. I'm so happy to see you all again. You only have to outrun one person. Oh, yes. That's a good point. That's an excellent point you got there. Ooh, spray. All right. I'll take a look at that. But yes, thank you so much, Mama. I appreciate it. Yeah, the bear spray. I've not gotten any, but I don't know. I'm worried I would. Hi, Deborah. I'd spray myself because I'm just that person that's like, all right, bears, bring it on. And I've got the spray and I just point at my face by accident. And the bears would be like, we're not going to eat this one. She's bad. All right, everybody, I got to stop drinking my hot cocoa. Okay. Here we are. We've got some contempt issues going on in several cases out of Minnesota. This is the transcript from the show cause hearing involving the U.S. attorney who was like, put me in jail. So this is the transcript, and my goodness, it's really special. It's something special. So we've got attorneys here for the ones bringing the lawsuit, right? So we have multiple people here. Again, this is a transcript of the hearing, but we've got people being represented, and then, no information about it. So the judge is like, we need information. Now, the friendlies here are going to be the green, that's the friendlies, and then the orange, these are the U.S. Attorney's Office attorneys. We've got two attorneys here, Anna and Julie. The one we're watching out for here is Julie, right? Because she's, if you're gonna sass, I don't recommend sassing a judge. Just straight up. Now you're like, freedom of speech. I'm like, all right. Well, they've also got freedom of putting you in jail. So yikes. Yes, I know, I'm so excited. Well, yeah, not orange. That's for no reason. Just randomly chose that one. So just to round out here my color scheme, if it's pink, it's going to be the court. So green for the good guys and gals and everyone, and then orange for the bad people. Oh my gosh. All right, let me write out what this is here. I'm getting distracted already. So transcript, script here of a show cause hearing. Well, that's not a C. There we go. Cause hearing. All right. And U.S. Attorney. I don't know. What should we say about the U.S. Attorney? Goes crazy, goes bonkers, loses his job, loses future job. I don't know. Has things to say. How about that? U.S. Attorney. We're going to call her Miss Lee, and we're going to say she's got stuff to say here. Oh, my goodness. Oh, absolutely. This is going to be a great one, everybody. This is going to be a great one. She's coming soon, Mama. If she's not in here, she's going to be on her way soon. For sure. So this transcript here, everyone, of course, was available for free online. That's kind of how we go about things. On my channel, I don't like to get anything that's out of Pacer and such because I want to make sure everybody can get the copy and fact check me if I screwed something up. So I'm looking right now just to see the time and date here. So we've got, this was in St. Paul, Minnesota, and St. Paul is where our circuit court is. So it's not in Minneapolis, it's just in St. Paul. That's where the courthouse is. Okay, so St. Paul, Minnesota, and then this was February 3rd here at 1:05 p.m. At 1:05. All right. There we go. Are we good on the sticky note, everybody? Hey, Murray. Yeah, I just got here. Oh my gosh, it's always good to see you, Murray. Yes. Hi, Dolphin. Welcome in. Okay, looks good. Thanks, Big Grandma. All right, so if we're looking good, I'm going to go ahead and get started then. Again, just a friendly reminder. Well, I don't even need to say this, but the moderators, if you all need to bring things down a little bit, if the trolls are out of control, we can kind of turn comments off for a little bit. You know the drill. Just let me know if you need to do that, or if we're cruising, we're doing all right. The other thing, oh, thanks, Murray. The other thing here, I want to remind everybody about is if we get to 100,000 likes, I have a bonus case that I will go through. We'll do like a little 10-minute case brief on a landmark case. All right. So if we hit that 100,000, I've actually got two I'm looking at right now. Ooh, I don't know which one we'll do, but I will go through that later on tonight if we can hit that number, just for fun. It's just for fun. No pressure. Just for, oh, Mama, that's funny. Get your tappers out. All right, here we go. Let's dive in. We have 5 petitioners here, but they're not going to be talking. This is a hearing that the court requested, and it's a show cause hearing. Old school, we would call it a contempt hearing. Now it's just very simple because you need to show cause why you are not in contempt with the court. So it shows you who has the burden here. Like, you have the burden of showing that you did follow the rules. That's how we phrase this. We have Judge Blackwell here. who is a U.S. District Court judge there in Minnesota. So we have appearances here. We've got Ms. Kelly Vaynerman, sorry about that, but for the petitioners, again, we have 5 of them. And then we have 2 U.S. attorneys here, and it's Miss Lee that really, that's so this could be definitely a career ender for her. Yikes. I laugh because it's awful. All right. Court reporters are down here, so that should keep us in line here so that we know what's going on. All right. And all right, let's dive in then. The court, please be seated. Would you please call the cases? Law clerk. We are here on 5 different matters. Case number 1, Segundo. Case number 2, Oscar. Case number 3, Jose. Case number 4, Roman. Case number 5, Juan. And case numbers are at the very end. Everyone, I'm adding this in for you if you want to look them up. The court, back to the court. All right, could I have the parties first note their appearances, starting with the government? Good morning, Your Honor. Julie Lee, and with me, Miss Anna Voss for the government. All right, good afternoon. You may be seated. And then for the petitioners, if you would state your name and which matter you're here on. Miss Kelly. Good morning, Your Honor. Kira Kelly here on behalf of Oscar O.T. and Juan. The court. All right, good afternoon. Good afternoon. Irina Vaynerman from Groundwork Legal for Oscar O.T. Good afternoon. You may be seated. The hearing this afternoon concerns compliance with the court orders. Not policy, just compliance. Nothing else. I've had so many issues with non-compliance in just this past week that I called for this hearing. Today's focus is just on those who were attached to Miss Lee. So what I intend to do at this hearing is first to make some general remarks to set the table. Next, I want to respond to the submissions I received from Miss Voss and Miss Lee within the last couple of hours. Oh, they don't like that. Ooh, they do not like that when you're filing a bunch of stuff like right before the hearing. Ooh, they don't like it. Then third, I do want to hear from Miss Lee on each of the 5 matters, the cases, to help me to understand why the non-compliance and why it takes so many different communications and follow-ups from the court seeking compliance. And then last, I'll have some questions for the government. The petitioners will have an opportunity to comment if they wish, although the focus of this hearing is the court's understanding, trying to reach some understanding with respect to the non-compliance. And what I really want is to fix it going forward. So the general comments, as I hope everyone here agrees and acknowledges, that a court order is not an advisory, and it's not conditional. It is not something that any agency can treat as optional while it decides how or whether to comply with the court order. The authority exercised by the court is derived from Article 3 of the Constitution and is not by dint of the parties' agreement with the ruling itself. That authority under Article 3 only has meaning if the court orders are obeyed, adhered to promptly, fully, and in good faith. That obligation matters most where liberty is at stake. Detention without lawful authority is just not a technical defect. It is a constitutional injury that unfairly falls on the heads of those who have done nothing wrong to justify it. The individuals affected are people. The overwhelming majority of the hundreds seen by this court have been found to be lawfully present as of now in the country. They live in their communities. Some are separated from their families. When a release order is not followed, the result is not just delay. In some instances, it is the continued detention of a person the Constitution does not permit the government to hold and who should have been left alone. That is not arrested in the first place. You all, that is respondents, represent the United States. That carries obligations with it. The DOJ, the DHS, and ICE are not above the law. They do wield extraordinary power, and that power has to exist within constitutional limits. When court orders are not followed, it's not just the court's authority that's at issue. It is the rights of individuals in custody and the integrity of the constitutional system itself. Wow, this judge is on fire here. So with that said, I want to respond to the submissions I received from Miss Lee and Miss Voss, and I received them just under 2 hours ago, but I want to address certain points with respect to those directly. The government makes the point that some of the attorneys currently are under extraordinary strain, and you are obviously telling that to this court, understanding that the operation that explains this process is not an operation that's driven by the federal courts. I do accept that I do accept that Operation Metro Surge has generated a volume of arrests and detentions, and that has taxed existing systems, staffing, and coordination between the DOJ and the DHS. I read that in your papers. I understand that. I also don't have any reason to take issue at this time that individual attorneys, including those appearing here, are working in good faith and under difficult circumstances. But those facts, even taken as true, do not answer the legal problem that is present for this court. If the government undertakes an enforcement operation of this scale, one that results in detention of large numbers of people, including individuals who are lawfully present in the United States, then the government assumes a corresponding obligation to ensure that each detention complies with the Constitution and with court orders governing release. The volume of cases and matters is not a justification for diluting constitutional rights, and it never can be. Ooh, that's a power move right there. It heightens the need for care. Having what you feel are too many detainees, too many cases, too many deadlines, and not enough infrastructure to keep up with it all is not a defense to continued detention. If anything, it ought to be a warning sign. But what you cannot do is to detain first and then sort out lawful authority later. Continued detention is not lawful. Just because compliance with release orders is administratively difficult, or because an operation has expanded beyond the government's capacity to execute it lawfully. Ooh, goodness. This court is not persuaded by the suggestion that detailed release requirements are the source of the problem. In many instances, I have had to not just issue an order, but another order, about 7 or 8 different touches sent to the government, simply asking for the date, time, and location of the release of someone who was ordered released, in many instances a week or more in the past. And why that is so difficult, I cannot understand, because there's obviously a person associated with the government who is going to the detainee to release him or her. You have their name. You can carry with you a form. The name is on it. Just write the time on it and send it to the DOJ. That cannot be a reason, a source for this problem of the non-compliance, because that's too easy to fix. And I don't even work for the executive branch. Ooh. Yikes. But the requirements that the court has in place exist because individuals were being detained without lawful authority. They were being transferred contrary to orders or released in ways that undermine the relief that was granted by the court. The precision that the court here, not just me, but all the judges, the precision that we are requiring is not meant to be punitive. It's remedial in nature. So to be clear, this hearing is really not about trying to find ways to punish individual lawyers or second guessing good faith efforts. It's about institutional compliance. So, Ms. Voss, I don't take it at all that it's the government's position that Operation Metro Surge has outpaced the government's ability to lawfully process detainees and comply with judicial oversight. That's not the government's position, is it? No, certainly not, Your Honor. Right. And does the DOJ feel that just because it has or needs resources to process all of the claims and comply with the court orders, that is a reason for the court to be relaxing constitutional requirements? No, certainly not, Your Honor. So I do take compliance seriously. And as the government well knows, you may be seated if you don't comply with the court's orders. So this would be, he's telling her to just go ahead and take a seat. Every time you address a judge, you need to be standing up. You've essentially painted this court into a corner because what are we supposed to do? We're here to determine what the law is, and we're here to sort out whether the detentions were lawful or not, and to issue orders for release if we find the detentions were not lawful, and to oversee that gets executed. And when that does not happen, then here we are. Ooh, this judge is on fire. And in our case, the court has had hundreds of these at this point. And the court is busy too, and made all the more busy if on a given day we ask within 48 hours to be notified of the date, time, and location of the release of someone who's been ordered released, to receive nothing at the time that has been ordered. Send a follow-up and receive nothing. Send another follow-up order and then receive a response that doesn't answer all three questions. You might get one, you might get two, and then you have to respond again. And in some instances, find that the person hasn't been released at all, as had been represented. This is I'm taking a pause here for 1 second. We also had a show cause hearing in DC over the JGG case, right? Remember the 5 people who were like, oh my gosh, you're going to send us to El Salvador, right? So the judge did find probable cause of violations, intentional violations of his order. And he is saying a lot of very similar things here. So that's another situation. They're still working it out. They're still trying to figure out what exactly happened, setting dates and times and such. So just FYI, this is in Minnesota. And all this really means is that what should be a straightforward order, we have heard the arguments, we have found the detention to have not been lawful under the circumstances. Person should be released. We find just repeatedly that that's not enough. It takes repeat after follow-up with the government. And we'll see some of those in just a moment when we go through the matters. So I'm going to stop there. just by way of background and follow up on the responses I received from Miss Lee and from Miss Voss. And if you want to come up to the podium, Miss Lee. So we're doing a sidebar. There's no jury here, by the way, when we have these kinds of hearings. There's no jury present. So this is just the attorneys and I expose anyone that's hanging out in the courthouse that day. All right, Miss Lee's up. Yes, Your Honor. I would like to walk through the 5 matters and get a better understanding of what the issue is and what we might expect going forward. So if we could start with Segundo. Your Honor, may I approach? I would like to present some. You have approached already. That shows an experience. Thank you. Documents are handed to the court. So that's the first case, Your Honor, that I have in front of me here, and I tabbed it so it'd make it easy for you to kind of follow. That's crap. Sorry. I'll put a little dash if I think it's crap. Okay. Not good. Don't say that to a judge. I have the case materials in front of me here as well, so you can proceed. So I received okay, just to have some background, I was put on this special mission to help with the U.S. Attorney's Office. What the H is that? With all the habeas claims that they've received, they are overwhelmed and they need help. So I have to say, stupidly enough, to volunteer. I started with the agency on January the 5th. As of today, it's been more than 4 weeks, and I just got my PIV card to the DOJ system yesterday. So I'm going to put in my own personal thoughts into this one, everyone, to just, as another perspective from an attorney that's worked in court. This judge doesn't give 2 shits about this. This judge doesn't care if you just flew in from, the Bermuda Triangle and just plopped down on the chair. If you're in the chair, if you're in the court, if you're at the table, be prepared or get out. That's how it goes. So this piece here is like, oh my gosh, it's so hard. I don't have enough, blah, blah, blah. The judge doesn't care. Too bad, dudes. So here's the court again. Where were you working before? I was working for the Department of Homeland Security as an ICE attorney in the immigration court. That's not good. Okay, so in January 5th, when I started with the agency, I have to be honest, we have no guidance or direction on what we need to do. And so when you showed up, they just throw you in the well, and then here we go. That's the analysis here. Again, this is Miss Lee for the government. I was tag along with attorneys during my first week of my assignment there. So this one here, the first case was assigned to me actually on January 26th, which is about the 3rd week of the 3rd or 4th week into my job. I received the assignment on the 26th of January at 11:14 a.m. I filed a response immediate at the same day, 4:08. Not sure about that. Right, like it's a flex. That's no flex. And during that time, the respondent already had transferred to Texas, and it was at around 2:37 p.m. I apologize. It was not transferred to Texas, but the respondent was transferred from Texas to the Whipple building at around 2:37. We're in Minnesota right now, just FYI. This is the Minnesota court, just to keep it clear here. And then he was transferred from the Whipple building to Sherburne County Jail on that same date at around 5:00 p.m. That's the timeline I was able to see in the system. I received your orders and I sent it out just a few minutes shy after he was sent back. He was sent from the Whipple building to the Sherburne County Jail. I sent it to them at around 5:38. And I did not receive that order with how the agency set up. Usually our paralegal receive the notifications. Whoa, let's pause for a minute. Is she saying her paralegal knows how to do it, but she does not? That's not a good look either. And they send to me for review and processing. And with everything going on, I did not receive the order until it was too late. The next order that showed up in my email inbox, it was on 1-30. That's when you have an order for us to question about. Where about this party? Where about the petitioner? All right. The court's like, right. I sent a follow-up, if I may. Yes, that's the court losing its cool again. And we're back at the court. This began with an order that granted the habeas release and ordered immediate release on January 27th from this court. Quote, respondent shall immediately release petitioner from custody. Within 48 hours shall file an update on the status of the petitioner's release. End quote. And that would have been on January 29th. There should have been a notice provided. There was no 48-hour update that was filed. And then on the 30th, there was a text order from me ordering to file an update, reminding that there was an order to file an update within 48 hours, and then saying file a letter by no later than 5:00 p.m. on the 31st, showing cause why there shouldn't be contempt held for violating this court's order. Yikes. We're about the judge. This judge. Continuing with the judge, that's why I've got a little pink mark over here. All right, so this is the judge again here. January 31st came, no letter was filed by 5 p.m. either. I'm going to pause for a second here. If a judge is texting you stuff, you're already wrong. You're wrong. Whatever it is you're doing, it's wrong. So you shouldn't have your judge chasing you down. You need to make sure that you're available. The other thing too, if they say get it by 5:00, you get it by 5:00. If you just write on the sheet of paper, I understand what you said, I have more to come, then you file. You can't just like not answer when you're given a specific date and time to file something. Even if it's like a coloring page, you know, do your best, you're gonna have problems. Here, in the wording, oh my gosh, yes. And it continues. And then on February 1st of 2026, Petitioner's Counsel, not the government, Petitioner's Counsel filed a status report stating that the petitioner still had not been released, although immediate release was ordered on January 27th, and he was here in Minnesota. So the attorney for the petitioner was the one that told the court, which is very similar to what happened in several of our cases in DC. And then February 2nd, there was an order to show cause from this court, ordering respondents to immediately file an update regarding petitioner's release. And then on February 3rd, a day later, there was still no immediate update, no written memorandum filed. And then we learned the petitioner had been released on February 2nd at 10 p.m., and which we learned from a representation that was made in a different case, not in the Segundo matter. We learned he'd been released on February 2nd at 10 p.m. Still no direct response to the date, time, location of the release. And so that's what led to the order to show cause. And I hear, the concerns that are raised by the DOJ with having to comply with the specificities, thank you, needed a moment, specificities that the court is asking for. But look how much trouble it takes in response to a simple inquiry to file an update on the status of the petitioner's release. On January 27th, the court had to ferret out its own answer. In essence, days later on February 2nd, what can the court expect going forward? Because this is obviously not workable, and it's certainly not an example of complying with the court's order, unless you feel it is. Hold on here, everybody. There we go. So then Miss Lee hops in. No, I don't feel like that is it at all, Your Honor. And I'm trying my very best to help to come up with a system or, a procedure somehow so that we, the SASA people taking on the detail, can help moving it forward and smoothly and in complying with the court. And I'm not defending all the misbehavior, mishaps on the case, but what I can tell you too is, Judge, that most of the email was sent to my DOJ email. Oh my gosh. Is she going to use the wrong email defense in front of this judge? Oh my gosh. I would die of embarrassment. All right. You don't say that to a judge. All right, so here we go. The email was sent to my DOJ email, and I did not receive it until it was too late. And I still am having trouble accessing my DOJ email. So everything, if it was in my ICE email, then yes, I receive and I will respond. If it's sent to a DOJ one, I don't have a way to access that system. But as for what we are moving forward, what are we going to do, Your Honor? May I approach? Yes, you may. Thank you. Here we go. Thank you. Documents handed to the court. Your Honor, those are a couple of the emails that were sent to me from the petitioner's counsel of how hard I try to be in compliance to fix the system. My good Lord, this lady needs to stop talking. And to get the person released. And if you will flip to the last page, during my first week, I don't want to say the number, but that's how many hours I put into this work because I did not know what I was expected to do. Now, pausing again, if you're incompetent, you have to call that out on yourself. Those are the ethical rules. If you're incompetent to do the job, you have to say, I've got to walk away from it. That's ethical rules. On the second week, the number increased, almost double, Your Honor. Jesus Christ. Okay. I'm sorry. Oh my gosh. Exactly. All the resources. Exactly. So this is Miss Lee. She is a government attorney, and the court in Minnesota is saying, why are you not in contempt? And here's the court coming back. So are you telling the court that you were brought in brand new, a shiny brand new penny into this role, and you've received no proper orientation or training on what you were supposed to do? I have to say yes to that question, Your Honor. What is this sass that's in here? That's interesting. Right. All right. You can proceed. Okay, and so I slowly figured out what is it that needed and what the requirement that we need to do for the full lifetime of a habeas. Oh my gosh, from the start of the petitions when we received it until the end. You didn't do that in legal research and writing in law school, apparently. And since that point, on this last week, that's when it's like, okay, this is the process. So I do now have a process in place of going forward, what we need to do so that we can comply with the court. And as the court can see, those emails are evidence that it's working. Goodness gracious. I think she's already been fired. Yeah, I think she's been fired already. And rightfully so, my humble opinion. Here's the court. Yeah. So is then each attorney within your office making up his or her own process? I don't know about that, Your Honor, but this is the worst I've ever seen. Oh my gosh, this attorney. No. Oh my gosh. Let's see. We got to move back a page and then pull back over. Here we go. Just a second. Can't believe it. All right. I don't know about that, Your Honor, but as the SASA's attorney, there are 4 of us, and we are trying to figure out what do we need to do to handle this operation. All right, let's proceed to the next case if we could. Yes. And I would like to next, as to the next case, may I approach, Your Honor? So anybody notice how she interrupted the judge here? So the judge was speaking, and it's not like a TikTok live here. The judge is speaking, everybody needs to shut up. So she just zoomed right in here and cut this judge off. All right. Tell me you have no experience in trial without telling me. Here we are. As to the next case, may I approach, Your Honor? Yes, I'd like to hear about the Oscar case. Yes, documents handed to the court. So thank you, everybody, for the gifts. Appreciate that. Right. All right, so here we go. I'm not sure. That's a good question. I think sometimes people interrupt because they're in such a rush to make their next point, but you can't be in a rush to make your next point with a judge. I mean, they're just like sloths. They move so slowly. If you throw stuff at them, they'll tip over. So you gotta be careful. All right, here we go. Handed the documents to the court. I suppose by way of protocol, it would be proper to have shown what I'm receiving to the petitioner's counsel. So if you would hand that to them, did you have a copy for? I don't, because I have not redacted all the information, but these are the emails and the correspondences that I worked on the case. And it shows that we're not lacking of not following up or not doing our job. Oh my gosh, everybody. Oh my goodness. You don't get to do that. Do you have a copy for the other side? That's rule number 1 for trial work. Always have a copy. You can't just be giving the judge papers. Like, you're not just like handing in like, oh, here's my assignment. You don't have something for the other party. You're not supposed to be giving that information away. Everything has to be equal. She said she's afraid they'll target her. Well, we'll see. We'll see. I mean, she has been in the field for a long time, and her stance on immigration is very similar to the oranges. So, I mean, that's one of the reasons why, in my humble opinion, everybody, people who are still there are either trying to light the last candle or they don't care about ethics. So we're going to have to kind of figure that out for her. I'm feeling like she doesn't care about the ethics piece of it, but we'll see. We're only a few pages in, right? So she's saying, we are doing our job. And the court said, well, if you have unredacted sets of information, I'll tell you what, I'm going to return it to you. So the judge is like, I'm not even going to take it. Oh, Murray, we made it. Okay, everybody. All right. Oh my goodness. That's so exciting. We'll go we'll go through this a little bit more, and then we'll do the bonus case. Yay. Thanks everybody for all the likes. I appreciate it. Here we are. Well, if you have unredacted sets of information, I'll tell you what, I'm going to return them to you. And she says, okay. And that's what a judge has to do ethically because she screwed that up. And I have my own materials and facts on the case here anyway. I'll just give it back. Thank you, Your Honor. Okay, so for that, again, it was during the assignment in the second week of on the job. Again, at this time, I have not sworn as a U.S. attorney. She hadn't taken her oath yet, which is a huge no. You can't be practicing in a federal court without having taken your oath first. You just can't do it. She should have gone to somebody and said, I need the oath. It doesn't matter who. You go to somebody, you're like, here's the oath. You need to give it to me, or she shouldn't be practicing. Again, at this time, I've not sworn as a U.S. attorney to present or have cases in front of Your Honor. So everything goes to the chief. I get nothing, no notifications, nothing at all, except for whatever that was sent to me to work on. I received the assignments on the 12th, and I sent a follow-up email to the offices of Principal Legal Advisor for documentation and for declaration for the deportation officer declaration. And on the 14th, I file my response with the court. I receive the court's order through all the email exchanges within the office because the paralegal will receive it, download it, and they will send it to me. Sounds like the paralegals are running the office, and sometimes that's really the best. Hi, EE. Oh, thank you so much. Thank you so much. This is really getting crazy. Hadn't taken the oath. Now, I'm not going to say that's going to invalidate the work, but I will say there's going to be questions. Absolutely going to be some questions about that. On the 17th, 3 days after I file my response, I receive your order, Your Honor, at around 10-ish, 10:12 a.m. So let me stop you there. Yes, because that January 17th date is in my timeline also, this petitioner that I refer to as Oscar here was, again, a petitioner who had no criminal... There we go. There we go. For some reason, it's fighting me. History that warranted mandatory custody, and he was apprehended by ICE on January 10th of 2026. On January 15th, there was an order from this court that he had been ordered released, and respondent shall confirm the date, time, and location of petitioner's release within 48 hours from the date of this order on the 15th. January 17th, which was the date you were referring to, is when you first received the order. Oh my gosh. And she interrupts him again. And then the judge comes back in and says, received the order because it didn't get to you within your office. Yes. There was no 48-hour update that was filed on the 17th. And then on the 19th, 2 days after that, the court writes again, quote, respondents were ordered to immediately release petitioner from custody in Minnesota and to confirm the time, date, and location of release within 48 hours. That hadn't happened. Oh, thanks for the gifts, everybody. Oh my gosh. Thank you so much. Appreciate it. I'm so thankful for the support and the amount of ink I'm able to purchase. So thank you very much. And so then the court is saying that I wanted a letter no later than 3:00 p.m. on the 19th showing cause why you shouldn't be held in contempt for violating the court's order. Then on the 19th, I'm told the petitioner was scheduled for return to Minnesota on a flight from El Paso, on Tuesday, January 20th of 26, and that he would be released upon his return. That was on the 19th of January. On the 20th, I write because we'd received no notices that the release had taken place. Quote, respondent state petitioner is scheduled for return and release in Minnesota on January 20th. Respondents must file an update by the end of the day on the 21st is what I'd asked for, quote, stating the status of the petitioner's release, end quote. Then we learned that on the 20th, when the release was supposed to have taken place, there was no release. Instead, we're told that counsel for ICE had represented to petitioner's counsel that the petitioner was currently on his route stop in Albuquerque, New Mexico, not El Paso, Texas, and is scheduled to arrive in St. Paul on Saturday, the 24th. And this is already then 9 days after this person had been ordered released and found to have been unlawfully detained in the first place. So 9 days later, he's still in custody, now being flown from El Paso to Albuquerque, New Mexico. So the petitioner's counsel then files a motion for contempt because of the facts as I just stated them. On the 21st, I ordered then Ms. Voss to file a written response. I'm sure she had more than one day where she regrets how well I know her name, since most things end in, get a hold of Miss Voss, but I ordered respondents' counsel, Miss Voss, to file a written response by 4 p.m. I gotta have a cocoa break here, everybody. Cocoa break! What are we thinking here? Is it as bad as I think it is? Yeah, I mean, it sounds really bad in my opinion. So, yeah, it's looking bad. Oh, that's a bad. Oh, you know he's mad when he's like, I know your name. And now, so you're done. You're no longer welcome here. And judges can do that. If they've got a legitimate reason, a legitimate conflict, they can ban attorneys from coming into their courtroom. So you either have to hand your case off to someone else or they have to reschedule with a different judge. That can actually happen. Halfway feel sorry for it. No, I'm not getting that, Vicky. Nope, I'm not getting I'm not there yet. Maybe because I can see how many mistakes she's making and her competence is so low that she should have pulled herself out of the situation and did not. We'll see. We'll see. Maybe we'll pick some good things up here. Oh my gosh. Gator, thanks. I don't even know what a gift gallery is. Oh my gosh, I appreciate you all so much. All right, here we go. Here we go. By 4 p.m. on January 22nd, providing the factual basis for why I was told in the first place that the petitioner was scheduled to return to Minnesota on the 20th on a flight from El Paso when he in fact remained in ICE custody in Albuquerque, New Mexico. Ms. Voss responded on the 22nd, explaining the timing of when she learned the facts. And let me pause there to make another point kind of clear enough. Ooh, that's bad. That's another setup for a scary moment here, everybody. I wholeheartedly embrace the notion of a unitary executive. I'm not sure how I feel about that, but all right. As in DHS, ICE, and the DOJ, all part of the executive branch. Okay, that's all right. I was worried. And if there's a problem in the restaurant, what? Oh, I don't intend to go into the kitchen to try to figure out who makes the bread. What? That's fantastic. I'm sorry, I'm going to have to go back a little bit. I was like, that can't be restaurant, can it? All right, back in the truck up again. Oh my gosh. All right, here we go. And if there's a problem in the restaurant, I don't intend to go into the kitchen to try to figure out who makes the bread. And all of it is part of the executive branch. And so it is not an excuse to tell me you contacted ICE because ICE is also part of the unitary executive for accountability purposes. That's right. When one screws up, they all get called out on it. But in any event, on January 24th, there was no confirmation of release filed stating that he had been released on the 24th either, 9 days later. And in fact, he wasn't even returned on the 24th. So then on January 26th, we're still at it. And again, I'm here referring to an order for release that was on January 15th. State the date, time, and location. And this is the follow-up I'm still having to do because I still don't know. So then I hear from the government and order the government that the government on the 26th must file an update by 4 p.m. on the 27th of January, confirming the date, time, and location of petitioner's release. On the 27th, I hear from you, Miss Lee, and quote, I want to inform the court I've received confirmation regarding the petitioner's itinerary and confirmed that petitioner will be transported back to Minnesota via commercial flight today, end quote. However, due to safety concerns, you asked for an extension of time to provide an update on his release today prior to midnight. And at which point I granted the extension of time and asked that an update confirming the date, time, and location of the release be provided no later than 10 a.m. the next day on the 28th. 15th ordered release. Now we're to January 28th, 13 days later, for someone who was not lawfully detained in the first place. So then on the 28th, Ms. Voss requested a brief extension because they had not received the prior order until later in the day, which was an issue, I think, with the notice from my clerk's office with providing that notice. And so then the update, we wanted the updated response from the government by 8 p.m. on January 28th. On January 28th, I do hear from you, Miss Lee, at 9:17 p.m., stating the petitioner was released on the 28th. Ooh, it's not. At 4:30 p.m. in Minnesota. I'd also asked for information about what the safety concerns were, and you don't have to say what those were. It's enough to say that I asked about the safety concerns. Then I followed up in 2 other follow-ups from the court asking what were these safety concerns that explain this delay. And to this day, I've never gotten an answer despite the follow-up with the court. Ooh, and I put that issue under seal, so it need not necessarily be discussed in open court. But I've gotten no responses at all for what the safety concern was. And Miss Lee, am I right that for just, you're correct on the dates and the times. And yes, on the 27th, when he was supposed to be landed in Minnesota, St. Paul, Minnesota at 9:31. I waited for a few minutes to make sure the plane landed. And then I checked the airline. They said the plane was landed safely and actually a few minutes early. So I reach out and check again to see where's the respondent so that we can get him, not respondent, but the petitioner, so that we can get him released, and found out that he did not make it on the flight because the airline declined to let them on. Wow. Oh man, you got to get that sorted out ahead of time. Oh my gosh, maybe like Patel's girlfriend can pick him up in the helicopter. So I escalate it to the higher ups, and I also put it in my 24 font. She did not just say that, everybody. She did not just say that. Oh my goodness. I can't. Did you guys see that? She's like, all right, let me reread that a moment here. Okay, take a breath. So I escalate it to the higher ups, and I also put it in my 24 font. This needs to be done. And I asked for another commercial airline. And that's how he was on board. My goodness. Oh my gosh, I can't even take it. The next day. To land it here, Your Honor. But my question is, and I wanted to answer, Miss Lee, please. Yes, Miss Lee, you are not to talk over the court. See, she got herself into some trouble there. If I'm asking in writing and then having to pick it up multiple times thereafter to follow up with the follow-up questions because I've never gotten an answer, why have you not to this day provided a written response as requested by the court as to what the safety concerns were? Why did you not respond? All right, and I'm going to bring you one more paragraph, everybody, and then we'll hop over to the bonus. Oh my gosh. All right, so here we go. Why did you not respond? I draft a letter on the 28th at a long letter. Oh my God. Oh my God. What's the matter with you, lady? There's something wrong with this person. Yeah. All right, so I draft a letter on the 28th, a long letter, and sent it onto my superior so they can, actually send it on to my paralegal. That's a big difference. Is it going to your superior or your paralegal? Big difference. So that they can file it with the court with all the flight information and everything else. but Miss Voss already told me that she took care of updating the court. Therefore, that letter was never sent the court. All right, so that letter would have explained to me what the safety concern was. The letter was including the flight information for each and every single departure. Miss Lee, Your Honor, not. Oh my gosh. All right, everybody, we've got, I know, I've got the puzzle piece, and that means we should move on to our bonus case. Although this is very fun. Oh no. Oh, I lost the first one, everybody. Fingers crossed. Here we go. We're going to do it. We did it. Oh my gosh, was that a galaxy? Oh, thank you so much. Wow, Army Mommy. Oh, I appreciate that. I appreciate it so much. I truly do. Today, my kid's like, you need more black ink. I was like, what do you mean? So yeah. We use it. That absolutely, with my 3 printers, I have 3 full printers that I use every day. So, and I love them. And it's not right, but I do. All right, everybody, here we go. Bonus case. I've got 2 options for you here that you can choose from here. Yes. So the first case that I've got, which is an option here, is the Bethune-Hill versus Virginia Board of Elections. Both these cases have election law involved in them, all right? So this is a 2017 case, and we've got you probably have heard of this, actually. We've got some questions about the redistricting going on here and whether or not redrawing the legislative districts were appropriate or not. All right, so and it's in Virginia. So that's one. The second case, very similar. This one came out in 2012, so it's older. And this is Arizona versus the U.S. Now, Arizona's always got a few little unusual things that they make sure to do in their voting. And I say that only because of looking through the fake ballots, right? The fake Electoral College ballots that were done, with the orange fella. Reading through that, Arizona's a little bit unique when it comes to how they set their stuff up. So you didn't need to know that, but there you go. That's for free. So this is 2012, and this case again is about Arizona State Legislature that passed a bill and whether or not changing the federal stuff was allowable or not. So we do have splits here when it comes for who voted for what and so on. So I guess the question is, they're both on states trying to change federal elections, which they can't do. And we have 2 different places. So the question is, do you want Arizona or do you want Virginia? Virginia, I hate living it. Well, it's dry, Ulysses. It's really dry. You probably wouldn't like that as a seafarer, but it's quite dry. Virginia, okay. As long as Miss Lee's not involved. Murray, stop it. You can't be so funny. You can't be that funny, but I gotta do a full life. I'm gonna die over here. No, I'm kidding. I'm kidding, TikTok. Sorry about that. All right. Oh my gosh, that's so funny. Hey you. Oh, moderators, you're great. So I'm seeing mostly Virginia, and don't feel bad because then Arizona will hit up next time. The next time that we go through that. Ooh, or the transcript again. Well, we could, can we, yeah, it is. It really is. And I can make a full post on it. Let's do, is it Jack? VC, could you and the compadres make a poll really quick and just say, do you want the bonus case or do you want to keep reading the transcript? If that's it. Transcript, well, I don't know if we're going to need, I'm not sure if we're going to need it. We may not need that poll. All right. Well, we can do that. I'll just put these to the side. And you can take a little screenshot, so then this can be your homework. All right, back to Ms. Lee. Okay. All right, well, here we go. No problemo. what is kind of nice is that this is the full hearing, but it's not a very long hearing. So we're really only a few pages from the grand finale. Oh, it really is outrageous. Okay, transcript. All right. You betcha. Okay, I can't, I'm going to try to not laugh so hard as I go through the rest of this here. But sure, we got a few pages, and then what I'm going to do is I'm going to just keep track here of our bonus cases. So you all, I'm giving you credit for one bonus case. So we can go through it next time. Here we go, everybody. Oh my goodness, Miss Lee, she's in some trouble for sure. Yes, it does. Maybe we don't need to know. I think it's okay. Gathering information's all right. Oh my gosh, VC, thank you so much. I don't do any of that. All I know is there's like a puzzle piece. That's all I know. All right, let's double check, make sure we know where we were here. So, oh, nope, we gotta go back. So I think this is where we stopped here. Texas Value. I think that's off the record. All right, here we go. Back to the fun language, and then we'll flip. So we've gotten a little bit of this already, but here we go. So Miss Lee, good evening. Miss Lee, I draft a letter on the 28th a long letter and send it on to my superior so that they can, actually send it on to my paralegal so they can file it with the court with all the flight information. Oh, thank you, everybody. I see the poll now. Whoa, overwhelmingly a transcript. All right, we made good choices. Good job. Ooh, all right, with all the flight information and everything else in that. But Ms. Voss already told me that she took care of updating the court. Therefore, the letter was never sent. All right, so that letter would have explained to me what the safety concern was. The letter was including the flight information for each and every single departure. Miss Lee, Your Honor, not... What's she gonna do to get herself into trouble? Miss Lee, please answer my question. Did the letter explain to me what the safety concern was, since that was my question? No, that's enough. Thank you. Then you can go back to my other question, which was why, if somebody is ordered release on January 15th, and they're not released for 13 days, January 28th, based upon a purported safety concern, when the court asks, what was the concern? Why, after multiple requests, have you not responded to explain what the safety concern is, since a person unlawfully detained was kept in detention behind bars for 13 additional days, and no explanation has been given? Why not a response? All right, so the judge is really, hi, girl in her brushes. The judge is really getting frustrated here. And he's not the only one either, everyone. We're seeing a lot of this kind of language for the first time, actually, coming through in a lot of orders. So Miss Lee, the reason that I did ask, and I was told if we provided all information, the protester will show up at the protester? Who's that? The protester will show up at the airport, and the agent and the other people will be in dangers. So I took it to heart, because during that time, it was very heated here in Minnesota with all the protests that was going on. Any public thing that was going on is at risk. Even myself is also at risk for putting my name and myself in there, Your Honor. That's the safety concern that I have. So she was saying, everybody's following this, right? She was saying that there was some kind of safety concern about the flights. And now she's saying, well, my safety concern is if you get off of a flight in Minnesota, right? I know, that's crazy. Oh my goodness. Exactly, Kaya. That's exactly right. Yes. Oh my goodness. So here's the court again. He's like, all right, all right. So my question has to do with the safety concern for why the person could not be put on an airplane in presumably Texas or New Mexico or wherever he was at the time. And is your answer because they were concerned if he were put on a plane that if he arrived here, there may have been a public reaction of some kind? Your Honor, he was escorted with other agents. He wasn't put on the plane by himself. That, you don't talk to the judge that way. That is not good. The original plan was to have agent escorted him back, and with the protest was going on during that time. I was advised to be careful of what information to put out in public so that for the safety of others. So this is where we're starting, everyone, to get into that piece I was talking about a little bit earlier, that the only attorneys that are hanging around are the ones that are like the undercover superheroes, and then the ones without ethics or knowledge. So we can kind of, think about that as we go through this process continuing. Here's the court again. So I'm not altogether following, since I was told that the safety concern was one the airline had raised. As for the airlines, I don't know why they denied his boarding and the agent's boarding. I don't know that, but I know that they were denied. I have the tickets, and I was going to present it to you with the tickets, and that it was bought for him and the agent, but they both were denied by the airlines. And when the various persons are detained and then flown to El Paso or New Mexico, are they flown out of here on commercial airlines then? I don't know, Your Honor. I don't know how to answer that question. That's one of the big secrets that the government's trying to keep secret. Goodness gracious. Do you know that they are flown out of Minnesota sometimes within hours, if not the next day, or of being detained? Yes, I know that they are doing that. And do you feel there's anything wrong with taking hours or days to fly them out of Minnesota when they've been, oh yeah, definitely. Just a minute, let me finish my question. Yes, to fly them out of Minnesota and then take 13 days to return them when they've been found to have been unlawfully detained. Your Honor, I did ask the same question too. I have not gotten the answer. That, like, you got to get that answer, right? Yeah, you've got to get that answer. And if you can't, you're going to be in some trouble. All right, let's talk about the next one, which is Jose, and the number is 26-244. And in this particular matter, for the petitioner known as Jose, again, there was nothing in the record that reflected that he had a criminal history that warranted mandatory custody, and he had also been then ordered for release on January 15th. And there had been an order that there be an update filed with the court within 48 hours, just confirming date, time, location of release. That he was not released at the 48-hour update, I received a notice on January 19th from a letter filed by Ms. Voss, and this is after, by the 19th, I had already put into place a show cause order since there had not been compliance with the court's order to verify date, time, location of release. Then on the 19th, I hear from Ms. Voss that the petitioner was released from detention on January 18th of 2026. So again, this judge is just going through like all of the timing that was clearly a violation of his order is what he's setting up here. Now the problem there, and I won't walk through all of the additional times I had to communicate with the government. Sorry, everybody. And I feel like I need to be extra careful with the Mesopotamia when I'm drinking my drink. I worry about that. Sorry, people. All right, here we go. Here we go. Oh, we'll just start right here. Now, the problem there, and I won't walk through all of the additional times I had to communicate with the government with respect to closing out the unconditional release ordered of Jose, but suffice it to say, the dates included January 22nd, January 30th, several of them on January 30th, because what I learned was that in the case of Jose, who had been ordered to have been released without any conditions, I learned that the government had imposed conditions on his release that were not a part of the court's order and that were not imposed based upon any consent agreement order from the court. Is that accurate? Whoa, that's really bad. That's really bad. If that's for sure's, if that's for realsies, somebody adding pieces to a court order, wow, that's really, really bad. Oh my gosh. Sorry, top 5 worst things ever that I've seen right here, number 1. That's accurate, Your Honor. And then your office has to then engage in more efforts because those conditions have been then struck because they weren't ordered by the court. Is that what you had to do then? I have to go back and pulling teeth to, oh my gosh, get things fixed. And it took a long time. For a long time, the ICE agency is work under the immigration court. And they have their own policy and procedures that she's saying to the judge right now. Oh my goodness. To get my back home colleagues up to date that federal court is not the same as how immigration courts operate. It took a long time and many order to show cause to explain and let them know that, come on, if you guys don't fix it, I'm going to quit and you are going to be dragging yourself into court. And I have to say that too in front of that in order to get it fixed. This whole paragraph here, this is basically, we're looking at an iceberg here. This is the iceberg. Right. Yeah, this, whoosh, that's not good. All right, and she's continuing on. This is her for the whole page here. I did put in my resignation from the job too, but they couldn't find a replacement. So I gave them a specific time and to get it done. If they don't, then by all means, I'm going to walk out. And before I walk out, I was able to release another individual, a juvenile. That kind of like a step, like a barrier. Like, wait, Julie, stop. You need to go back and get more people out. That's not her. All right, that's why I'm still here. I'm here just trying to make sure that the agency understands how important it is to comply with all the court orders, which they've not done in the past or currently. I'm here as a bridge and as a liaison with a really long letter, everybody, between the one that in the jail, because if I walk out, sometimes I wish you would just hold me in contempt, Your Honor, so that I can have a full 24 hours of sleep. I work days and nights. Are we getting your small violins out to play a tune for her? At least those conditions that she's in are a heck of a lot better than the detention center. Just because people's still in there. And yes, procedure in place right now sucks. I'm trying to fix it. And as you can see, the email that I sent to you, it has been improving, a great improvement. And last night, I had to stay up until 2:35 a.m. Oh my gosh, this is bad. That's bad business. You don't do that. I need a moment. Okay, that's so bad. And last night, I had to stay up until 2:35 a.m. just to get this documents ready for you. I can't say it's a waste of my time. Oh my gosh. What? Am I being punked? This is so crazy. But I could have sent so many more emails and get so many more people get ready to be released. And I'm here with you, Your Honor. What do you want me to do? The system sucks. This job sucks. And I'm trying every breath that I have so I can get you what you need. Holy buckets. That's so bad. This is so bad. Right. So apparently there's nobody else. If there's nobody else and you're incompetent, then you got to go. You can't just go into court and be like, well, I'm the last one they have. Like, well, what kind of law do you do? Environmental law. Okay. Well, why don't you take over as the Attorney General for the United States of America? True story. True story. You can't do that kind of crap. You got to be competent. And if they need more people here because they're rounding everybody up so quickly with nowhere to put them and nowhere to do it properly, then, you know, that's a them problem. Like, you're done now, lady. You and your stuff, we're done. Upstairs School of the Law. That's a good question. All right, here we go, everybody. We're screaming. We're screaming down to the ending here. All right, so I hear your frustrations and comments about the job. Oh my goodness. You know, I had a judge yell at me once for clicking my pen too much in court. He was like, does the state need a new pen? No, Your Honor, my bad. Meanwhile, she's like, I'm so tired. I didn't get enough coffee today. Like, what? What? Oh my gosh. Oh my gosh. That's why I like to have only clicky pens now. I don't know if anyone's noticed that. All my pens click, right? Because of that judge. Trauma. All right. Here we go. My question is, are you expressing those to the others who are, interrupting again. Just a minute, the others within the DOJ or ICE or DHS who have the role of carrying out the court's orders that require immediate release. How is this frustration getting translated? I write an email with big, bold font. Oh my God. Jesus, take the wheel. Take the wheel, Jesus. Oh my goodness. When you have a font that's big and bold, everyone's like, I know, that's for real. Like, how is this the world we're living in right now? This is no. All right. I got to pull myself together. Oh my gosh. All right, here we go, Miss Lee. I write an email with big bold font. I carbon copy Ms. Voss in it, and I said, here's what it failed and we need to fix it. You can't just have people sitting in a jail and drag me into court and explain to the court why the system fails. Oh my gosh. Whoa, I'm like, oh my gosh. Whoo, this is bad. This is real bad. And if they can't help me, then I am not, oh no, here. I'm not meant for this job. It's just like she sounds like she thinks she's important. That people would be like, okay, give her whatever she wants, including just releasing everybody from jail with their big bold font. I'm not meant for this job. And to be honest, Your Honor, I did put for a request to be transferred back, but no one were willing to come here to stand in front of you to explain and or to help to improve the system. Can we just start with one case? Can we just start with the Jose case rather than the full system? All right, here's the court's response. Oh my goodness, it is insane. She's not meant, you're right. Well, and you know, traffic court can be very difficult for some people. But the other thing too, yes, thank you, Liddell. The other thing too about traffic court is you can't fall asleep because you really don't need to do anything except for raise your hand. That's why everybody tries to get traffic court right before they're going into their big jury trials. Because they're like, I can sleep. Here's the court again. Do you, Miss Lee, because with this particular case, where it ended up is with the court having ruled that the petitioner had been unlawfully detained. And the remedy for the unlawful detention was that the person should be immediately released because they should not have been arrested and detained in the first place. And that's an excellent point. But it's weird that she's saying too, everyone notice that she's saying, we have all these people in jail. I was lucky I got a juvenile out and I wanted to get all these other people out, which is, not the road that the executive branch has been going down, right? Did we notice that? And I thought that was very interesting. Useful? No. Did she get fired? Yes. Why? Because you can't talk to a judge like this. You're done. Whew. Are you in any way defending the idea that for somebody who's been ordered to have been released unconditionally because they were unlawfully arrested, that the government or DHS or anyone should be imposing conditions upon their release that the court hasn't approved of? I'm not mad at her. Fair enough. I'm not defending it. That's why I have to go back and get them corrected. And it is corrected. But if you took a fight, I think she's saying flight. If you took a big, huge fight to get that done. Okay. Maybe it is fight. Oh my gosh. Hold on. Oh my goodness gracious. All right, here we go. I think it is fight, all right? But it took a fight, a big, huge fight. I really wanted to say flight, but that's the wrong word. To get that done and to move forward with the next case and the next case. Every day, every hour that we have tons of email and I pick up calls from any people that call to help with their cases regardless. So it is improving. It wasn't like that before, but because of my positions as an ICE attorney in the past and a SASA in the present, it took me a few weeks for them to understand that these are important conditions that we have to follow. These are important things that we have to do. If not, I'm going to put their names on the briefs and then you can bring them into court. That's not just you threatening me, Your Honor. I also go back and threaten them. Holy shit. Whoa. I'm sorry, I'm seeing spots. This is what she said to a judge, to a federal judge. This is what she said. If not, I'm going to put their names on the briefs, which is not a good idea ethically. And then you can bring them into court. That's not just you threatening me, Your Honor. I also go back and threaten them. That's really bad. Yeah, that's really bad. For not coming over the bed. I know, right? Yikes. All right, so let's go and see what the court has to say in response. Oh, goodness, I'm worried for her, but I don't care for her, so I'm all right. I want you to understand my goal in any of this is not to threaten you or anyone. What we really want is simply compliance, because on the other side of this is somebody who should not have been arrested. In some instances, in the first place, who is being held in jail or put in shackles for days, if not a week plus after they've been ordered released. That's my concern, is for the upholding of the rule of law and the constitutional rights of all concerned. And so that's my concern. I'm interested in compliance and not so much in threats. And I'm just trying to figure out how to get it out. How to get it. And I know the government has a concern about the growing number of requirements that the courts puts in place upon release of individuals. That happens because the things we learn. For example, if we say release the person immediately, then we learn that having transported him to El Paso or New Mexico, you don't bring him back. We learn that somebody is put out on the street with just the clothes on their backs and have to figure out how to get excuse me, everybody. back when they should not have been arrested in the first place. Let me make sure I've got the right page here. What? Make sure. 33. Yes. All right. In the first place, let alone flown halfway across the continent of North America. And so now we have to address that. We have to now say, bring them back. And then we say, all right, so you brought them back. We can't have them released when it's minus 14 degrees outside. And so now we have to address that. Don't release them in the circumstances that might endanger their health or safety. And so once that's addressed, then we can learn they've been released. But now conditions have been imposed that somebody who should not have been arrested in the first place is now being told you're going to be released if you wear an ankle monitor, which the court didn't order because the person was unlawfully detained in the first place. Then we have to go back and address that new issue. Oh my gosh, that's really bad. They're gonna have to go back into court again to have that taken off. The fact that they did it in the first place when they got the order that that person hadn't done anything wrong and was illegally being detained, the fact they still put an ankle monitor on that person is like, it's pretty bad. That's pretty bad, actually. And I hear the concerns about all the energy that is causing the DOJ to expend, but with respect, some of it's of your own making by not complying with orders. Do you understand that? I do. And I share the same concern with you, Your Honor. I'm not white, as you can see, and my family's at risk as any other people that might get picked up too. So I share the same concern, and I took that concern to heart. But again, fixing a system, a broken system, I don't have a magic button to do it. What the heck is she talking about? I don't have the power or the voice to do it. I only can do it within the ability and the capacity that I have. And every case I touch, I give it 100%. Never in my mind that one petitioner is more than the others. They're all important to me. But there are certain things that it takes time. It takes 10 emails to get a release condition to be corrected. It takes 2 escalations and a threat that I will walk out for that to be done. I took it to heart, and the agency is slowly seeing what the courts are doing, and it takes time for them to learn the lesson too and abide and comply with the court. It shouldn't actually. That shouldn't be difficult. There's a law, then you comply with the law, and then, the court shouldn't be at that level. I and Miss Voss here working days and night. Our emails just never stop. And as you can see, I would love to undo all of this stuff because no one wants to be in jail. And actually, honestly, being in jail a day to catch up with sleep is not bad right now. With all of the hours I've put into this job, that was another big final nail in her career. Miss Lee, I appreciate your candor. There were 2 other cases here. I don't need to discuss them unless you want to take issue with the violations the court has found with respect to those 2 other matters. No, Your Honor, but with respect to those, I figured out what the fault was, what the fail was. When I didn't know that I have to do all of the status follow-ups. Oh my gosh. It's only like a small paragraph. That's, to be honest, I thought it was, someone else's job. And then I figured out everybody's busy. So the one thing that I have asked my colleagues and I to do is when you send out for a release, now click a few more buttons on the email to do a follow-up and then a reminder. And that way the email will go on top of, Is she explaining email to a judge? Is she standing in front of a federal judge talking about how she's setting up her, files? Are you freaking kidding me with that? Yeah, oh my God. I don't know if she's doing it on purpose or not. It's so clear she doesn't ever work in front of judges here. All right, so here we go. The court, all right, Miss Lee, thank you. You're welcome. You can retake your seat. I have some questions for Miss Voss. Now, I do have to stop at this point, just sheer voice. So we made it almost all the way, everybody, through the transcript here. We only have a couple of pages actually left. And one of those pages is the attorney for the other side coming in and being like, no. Oh my gosh, that's really bad. Probably needs a mental hospital. Well, my goodness, everybody. It is hard. It is hard to be a prosecutor. It is hard to have, what'd she have, 85 cases? I'm not going to say that's hard. She can get over that. Because 85, yeah, that's a starter pack. But, you can't just, I just can't even believe you talk to a judge like that. Like, just for anything. Even if it's like an initial appearance and they're like not guilty or guilty. Like, you don't talk to a judge like that. You disrespect the court. You're not going to be able to practice in the court. And, we did see some of that disrespect coming through on all of the Orange's criminal cases, especially with the filings. They were taking it too far and being offensive and going to personal attacks and such. We saw that starting to sprinkle. But full blown, what the H? What the H here? The experience is not here at all. And it's inappropriate for her and incompetent of her to be in front of the judge. So you're looking for a lawyer, got cut up here for... That happens. That has to be the top 10 crash out. Oh, I believe it. This woman, that's the thing though. Who hasn't, quite frankly, if you're doing trial work and you're not up with no sleep for the entire trial and the 2 days before, and then hopped up off of goofy pills at the end because you're trying to not drink more caffeine, that's the trial lawyer's life. I mean, that's the world that you live in. So it's not like, oh, I had to stay up till 2:15. No, it's more like, hey, I got to bed at 1:00 last night winning, What they put up with. I know. Well, this judge too, I don't know that much about this judge. I've certainly not practiced in this area, this state either. But he seems pretty cool. And from what I've seen of the reports, he's just kind of like a, let's get her done kind of judge, as opposed to trying to, I've talked about this before, how judges tend to go one way. They can kind of be like, they kind of tilt left or they tilt right, but a lot of them are right down the middle, and those are the best judges, in my humble opinion. I don't care if I'm on the left or the right. I don't care. I want my judge to be down the middle. And he seems to be one of the middle road judges, and I really appreciate that. And he's put up, he's put up with a lot. And that, again, I think illustrates how our judges, honestly, and this is true, I've seen this in my own practice, they don't, like, the worst case scenario, they do not want to have to do unless they feel the person deserves it or needs it, right? So if you get a really, really, really super bad person, the judge isn't going to feel bad about being like, nope, you got to go. Following all the rules, right? But if you get someone that comes in and it's like, man, I just made some mistakes, I didn't know what I was doing and so on, the judge is like, all right, I'm going to give you 48 hours, fix your mistake, and let's see what happens. So they do like to do that. That's kind of part of the process of justice, so to speak. But yeah, there was, oh my gosh, Vicky, yeah, he showed her mercy. Perfectly put, exactly. Yeah, so we've got here Segundo, Roman, Oscar, Jose was one that we just talked about, and Juan here. So in almost all of the habeas cases, everybody, and there are a lot. As a quick side note, habeas corpus, right, which is you're being held by the government unlawfully, that's what it is. And so you put in a request and to go forward to be seen by a judge. It's supposed to be very rare. It's very rare because we are so slow and careful that we don't need it all the time, right? So it's kind of like the grand resistance, the piece de resistance. It's the big one. And you want to do everything you can in your case to make it so that you're not habeas. But the problem is here, there are more habeas court case, sorry, back up, beep, 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 back up the bus. There are more habeas corpus filings than I've ever seen in my whole life at this point. Then the number is just astronomical for this use of habeas. And it's the correct way to use habeas. I'm not saying people are, running with a bad writ. Like the writ of mandamus is very complicated, and some people get it and some people don't. But with habeas corpus, that's not playing around, and it's the most the most that I've ever seen. So right. Her career's corpus. Habeas is a thing if you want to make it a thing, right? If there isn't a word for it, then you create the word, start using it, and then boom, it goes in the dictionary. Oh my gosh, canceled all habeas petitions. That I don't know of at this point. I've not seen anyone that has been canceled. I have seen habeas cases where it has moved out of the habeas situation because they've been seen by judges and now have a court order and are going forward. Once you've been seen by the judge and once everything is sorted out so that the system knows you're there, and typically that's what this judge here was saying. Look, the habeas was not appropriate. This was not appropriate. And then, kick them out. And so that's how the habeas cases tend to evolve when it comes to, like, they just want their day in court and they're being held against their will. That's really all that's needed for a habeas case. Texas, Mississippi will not allow bond. Yeah, I'm not surprised. And I do have, and I plan to go through, there's two sets. I have all these great plans, everybody. And then I'm like, what happened to the time? It's gone. Or else some other real crazy things going on. There's a lot of crazy stuff going on. Okay, so I have right here, let me see if I can find this. Oh, where'd it go? All right. Oh, here it is. All right, so I've got a full pull-out here of the inadmissible aliens piece of the Aliens Act. Well, the Immigration Act, not the aliens. And there's a lot of reasons why certain things are allowed and certain things are not allowed. And so I do want to go through that with everyone who's been getting pretty confused, including myself, because people are just spitting out these names of court filings. And it's like, what are you talking about? And they mostly don't know what they're talking about. And that's all right. But, you got to learn it. If you're going to talk about it, you got to learn about it. And then one of my favorite things too, these are in hopefully my next live. Here's an application for a criminal arrest warrant. And you can compare and contrast it with this administrative warrant that they use just for immigration, right? So like this one can be signed by your buddy and your buddy can be like, yeah, there's probable cause, blah, blah, blah. And you don't need any kind of affidavits and such. That's what makes it administrative because it would not pass the Fourth Amendment. Meanwhile, for your criminal arrest warrants, every single element has to comply properly with the Fourth Amendment. So there are some really big differences between the two of them for sure. And so I am planning hopefully to be able to go through that as well. It's busy times now, busy times these days. Oh my gosh, everybody. Oh, look at all those likes. I appreciate that so much. And on that note, they're criminalizing everyone of certain, Meme NATO, and I'm going to be real with you here for a minute, everybody. I'm going to be real, right? There has been, in my humble opinion, no break in that ever. When we have had people of color in this country, there has been a problem. All right, so it's not a new one. It's just continuing on. I wish it would slow down. There were some inklings of it slowing down a little bit. But yeah, we got a little, backlash, and then we got to go forward again. For sure. Of course, you're welcome, Willie B. Oh, I'm happy to be here to help everyone. Oh, there's some crazy stuff going on. Crazy, crazy. I did post on the SAFE Act and a couple of other things, but if you've got questions on stuff or if I've not hit a topic that you're really worried about, just go to any of my posts and just write a question in and just say, hey, I got a question, and then just write out what it is, and I'll try to get back to you with an answer. So with that, take care, everybody. Have a wonderful night. I'll be back and see you all very, very soon. And as always,